decision, to be honest. I mean, because I think every plans will tell you what they're willing to cover, because it's you're paying out of your pocket essentially, right?
Yeah.
Are you gonna retain someone that's part-time, or do you want to retain only full-time employees? And you want to offer it to part-time employees. Now, I do want to caution you on benefits. If you open up a benefit to one employee, like a part-time person that happens to be, I don't know, a friend or whatever, you need to offer that same benefit to other employees. So it can't just be you pick and choose. That's where a lot of my employer clients make a mistake, because they don't like someone, so they don't want to give them the benefit. Like, it doesn't work that way. So keep that in mind. So, any common policies you want to cover?
So, we were going to talk about the new hire pay. I can just kind of mention.
Oh, I'm sorry. Let me go back.
So on the offer, let's start that you already know who you want to hire. There's requirements for the offer letter. On the offer letter, you have to be specific on what you want them to, the title, how much you're going to pay them. Are they going to be weekly, bi-weekly? Not be weekly, bi-weekly. How often they're going to get paid? How they're going to get paid up by the hour or by the salary. One of the things that I always recommend, if they're going to be salary, to find out exactly how much they will be making per pay period, because if you put the annual salary in there and for something doesn't work out, then you'll be liable if that person resigned their job to come to work for you. So just be careful on putting the annual salary in there.
Sorry, can you repeat what you said? I didn't understand that.
What was that?
Can you just repeat?
Yeah, I think they want to know what
I
you
didn't
offer
put that
that
last.
Maybe I just talked too fast, and maybe it makes sense. Okay, so I was trying to rush, and I know that I get nervous when I try to rush. So when you hire someone, on the offer letter, you need to be specific and let them know if they're going to be hourly or exempt. Okay. Right. Once you provide them with the exempt, if they're going to be exempt, then make sure that you divide whatever yearly income they're going to have and divide it by the times that they get paid, whether 26, 24, or 52, and then put that in that offer letter.
You have to specify that amount.
Yes,
You can't just put an annual salary.
Yeah, you can. I don't recommend that you do an annual salary.
You can, just not a good idea.
It's not a good idea, because there's been cases where the employee, and we had a situation in one of the jobs that I was working where they put in you're going to be making 150. That employee actually resigned their job to come and work for this company, and then when they came and worked for the company, he didn't work out. He didn't meet the expectations, so they had to let him go. And what happened is that he hired an attorney, and the attorney was saying, another attorney like Chase was saying, no, you promised him, it's in the offer letter, and it was 150 per year, so now you have to pay this much money, and there's penalties, and it's a big thing. So
you have to be very, very clear, because it becomes problematic. You have to also mention the paydays, because we can talk about that as well, because California requires that the latest you pay someone is the 10th and the 26th.
So does that conflict with the at-will law in this state?
Well, yes and no. Yes, just like the person can quit anytime, but however, if I relied on the offer letter and I left my other job and then suddenly I end up leaving and it's not clear, yes, you can terminate me, but then you also have to honor what you offered me.
Oh, because
so that's what she's talking about.
Because you mentioned $150,000 a year annual compensation, as opposed to mentioning the specific dollar amount, like $80 an hour.
Right.
No. She's not saying hourly rate. She's saying how are they going to be paid and how often. Needs to be in the offer.
So I think, like, for example, in our case, they mentioned the hourly rate, and then they mentioned that it's bi-weekly. Is that enough, or you have to go further and say that you'll actually get paid this amount?
No,
that's good enough.
Yeah,
it's good. Got it. Just making sure.
But there's more things that you need in the offer letter, just not.
And we don't have an annual total.
But
it's not in there.
But I'm not going to go through all of them. But one of the other things is that when they get hired, you want to make sure that you have a job description for that person, so they can sign off on it. And they understand the expectations, and you also put in there that other duties might be assigned later on, so they don't come back and say, well, that's not my job, that's not what you hired me for. So you kind of leave it open. And then there's also a lot of required pamphlets, and I'm just going by the bullet points that we have in there. So there are also a lot of required pamphlets that are required by law, that you provide the employee with their benefits. For instance, state disability insurance, sexual harassment, all those benefits that anybody can find out there, but you need to provide them when you hire them. And then the harassment, discrimination, retaliation prevention policy, that's also something that's required when they first enjoy the business or the employee.
Say it again? The harassment,
discrimination.
Yeah, that needs to be clearly, and it should be given to the new employee when they are first hired. More often than not, what happens is people will say, well, I gave them the handbook, and you know, we were talking about this before the seminar. What happens is that if you haven't read the handbook and you expect them to know what the leaves are, the state law requires you to cover these things no matter what. We need to give this to every single employee. These are the pamphlets, which is what Anita would tell you. Hey Frank, you're the employer. Going forward, when somebody comes in, or if they come to her, this is when she's doing your onboarding, I'm going to be giving them this flyers. And there are all these pamphlets that the state will give to you if you order them, and then you have to make sure the employee gets them. Otherwise, if you don't do that, you could have.
And there's a lot more, but a lot more forms. But one of the other things that I just want to mention, and this is the last one for this, is the arbitration agreement. The arbitration agreement is so important, and you can explain to him.
We're going to talk about a little bit about that.
Okay, okay, good.
So, one of the things that a lot of people do, the DocuSign electronic, is they'll insert the arbitration agreement into the onboarding documents. Under California law, arbitration is a right that you're giving up. You're giving up the right to a jury trial or a right to go to civil court. And so case law is very, very clear that you have to make sure the person signs that separately. You cannot just hide it on a sheet of paper to say you're signing away your rights. Now, a lot of us sign the terms and services in a lot of places. I don't know if you've seen, there's always an arbitration clause. Well, guess why? It is beneficial to the person who's offering it. They say it's more efficient, but the reality is you don't get as many settlements. It's generally a private judge. There's not much discovery you can do. It's whatever they decide you're going to get in damages, what you're going to get. It's generally is significantly less than what you get in a civil lawsuit. So an employee, California wants to protect employees. They don't want them giving up this right unless they knowingly give up this right in a separate agreement. So I always caution my clients, please don't shove this in. You need to sit down. You don't have to talk to them about it, but you need to make sure they sign it separately. At least explain briefly what it is. So.
Can an employee refuse to sign it?
Yeah, so
They can.
Because I mean, it sounds like it
They
will
can.
benefit them not to sign it.
Yeah, they can, and you cannot obligate them to sign an agreement they don't want. This is where it gets tricky now. Do you want to keep them? Here's where it gets into a possible wrongful termination, because Chase will tell you they engage in what's called a protected activity. You cannot require someone to do something they don't want to do.
Okay.
And so if they're saying no, and you fire them tomorrow, you may have a wrongful termination action. So, Chase is like, there's a reason he's in the middle, so we can point to him.
3 months and then sign.
There's some more leaves. These are a lot of leaves that I'm sure Anita will discuss. You want?
The what? The what leads? The
FMLA,
handbook?
pregnancy. These are the most common ones that people get
Yeah.
in trouble in.
So maybe I can just, and I think this will be the last time that I
Sure.
talk, but one of the things that are very important, and he mentioned it, Will. Ed Will is one of those policies or laws that you have out there that contradict itself, because even if you fire somebody with 90 days or whatever time it is, if you fire them, you still have to give them a reason why, because they might go and try to collect unemployment, and then unemployment is going to say, well, what was the reason? You had it in writing, I mean, it opens like a can of worms. But to be honest with you, Ed Will, I don't like it. I've been doing HR forever, and I like that policy because it contradicts itself, and a lot of people think, just fire this person. California will state, well, you cannot. I mean, you still have to have a reason to fire them. And then the bereavement leave. Do you guys? What was that?
Question?
Bereavement leave. Do you guys know how many days are for bereavement leave?
So he's saying that way.
See, 3 days. You will get them right away because now it's 5. So it's 5 days.
And actually, laws mentioned staff to siblings and children. It's banned in our county.
And it's
Yeah.
going to include pets as well?
I don't
think so.
Not yet.
Not yet, but
Well, it's California,
right.
But why fight that? Yeah.
But this is some of the policies that are very important in the handbook. Also, one of the things that you need to have in the handbook is the policies that you want to implement on your own. For instance, best practices, like I recommend you do this is the experience that I had prior, attendance problems. Maybe you have a camera in your building, and then you use that surveillance camera to fire that employee, but you had a policy for it, wasn't there, I was not aware it was there. So many policies policies, and when I do the handbooks for my clients, I always put all the laws that are required by law, and all the ones that I recommend, based on my experience, that I consider best practices, and then the other one is optional. You know, vacation policy, you don't have to pay vacation, it's really up to you guys, if you guys wanna give that benefit. However, it's for implementation, and it has a lot more benefits than just that. So,
and just again, to interrupt you for a second, if you're gonna offer vacation, you can't choose who you're gonna offer it to. This is where a lot of people get, I don't wanna give this person, I just like, doesn't work out. You have to give, everyone is the same.
I don't see there someone getting laid off, like, let's say the position is closing, how does that work?
Termination. It's later.
No.
We wanna talk about
So you can have people off, you need to make sure that the position really isn't, so I have had clients that are trying to lay people off as and the position still exists. And so, but reality also is it's not succeeding. It is so yes, you know, so that is when they're supposed to get unemployment is designed for being off. But right now you need to choose anyone. My experience, almost everyone unemployment is because they have last couple of years. So
you have to be very go ahead. You have to be very careful when you terminate someone, and for the reasons they mentioned, but also, you have to ask yourself, is it for attendance, is it for productivity, is it just because I don't like that?
The position is closing.
If you go for you, right?
Yeah.
But if I'm an employee and I see that somebody else doing what I used to do, that position still remains open. Or maybe I'll call it job domination, but in reality, it's because one of the get rid of you, you wanna give that to Sanjay. So then it becomes a problem. So I think we can.
I like to lay people off in non-process. Or
Yeah.
just some amount, you know, that's generally, and that doesn't mean you pay them, but the reality is you also keep them in mind, which is why a lot of times we get off, there's always a subsidy. It's not just a thing like that.
Question. Because when you obviously, some employees get written, right?
Yes.
That's a very contentious issue, I have the thing for one employee, right? And then doesn't sign off on that.
Because you cannot require sign Sarah to sign. They can acknowledge, you wanna make sure employees acknowledging, not agreeing, they're acknowledging they were written down. They do not have to do your write-up. Hey Frank, you were two mistakes single day. No, it wasn't. Okay, but here's the write-up, here's the doctor saying, you showed up like X, Y, and Z. You could say, I used to sign I don't agree. They can agree, but they have to say like God.
Yeah, but they agree.
I acknowledge and sign, at the same time.
No. At that point, what I would do, and I recommend this for the clients, is that you ask. No. That you ask somebody from maybe a manager or supervisor to be the witness, and then you can write it in there. Employee refused to sign, and then that person signs in there, I sign in there as the manager or supervisor, and us, the two of us sign. And that information will protect you, and if you explain to the employee that warning is going to go in his file, just exactly like he would have signed. The refusal to sign doesn't mean anything. He didn't want to sign, but I'll talk to you. You knew my expectations, you knew the reason why I was writing up. So it's always important to get a witness that has a manager or a lead or somebody, not just an employee, but somebody at the same level. You don't want to humiliate the employee and then a co-worker.
Or have a family member there.
Yeah.
Have a couple of times had their family member there and they weren't part of the team. You can't, don't do that. Don't embarrass employees here right now. And don't make an issue out of it. They're contentious, like I said, have a witness, make sure you stop documented, move on.
Here's the
Quick question, for jury, is it required that the employer pay or
Optional, they do get like walking words.
Hey,
Yeah, very little.
Yeah.
When it comes to the holiday, they say that you can have blackouts, like the company can have blackouts, but you can't go do it.
I agree, like it's thoughts on the details, yes, you can. That's not gonna get out of that dates first, they cannot take off.
For vacation, what you can do, you can set up a policy, because if you have a busy season, like in the middle of the year, maybe summer is your busy season. And you can say that it's only for emergencies. You're not gonna allow any vacation time during this period of time, unless it's an emergency, and they have to prove to you that it's an emergency. But you can block, but you have to notify them ahead of time, and I would recommend that you put it in the handbook.
We just got the real breaks, by the way.
Yeah.
So, Chase,
Now it's Chase's turn, so we should
Chase normally does, I'm sure most of the time, either meal breaks, I don't know what breaks are, but, what are some of the common mistakes you see when you look at some of the things you get from police?
So a lot of my cases have been actually wrongful termination and talking about these performance improvement plans and get all into the facts about why termination was not at will employment termination, actually wrong termination. But in my wage and hour cases, meal breaks, for example, so an employee needs to be paid 30 minutes, or needs to receive 30-minute uninterrupted meal break and it's unpaid. But you have to completely relieve that employee of all responsibility during that time. You can't make them stay on the premises. You can't generally, you should keep them on standby. Sometimes you can give them an on-duty meal break, but it has to be specific to that job, like it requires it, and they have to have an agreement to that effect. So that's generally what we look for. And then like for example, I was working on a case where a bunch of workers had a quota for their shift, right? And they had their own responsibility to go meet their quota by the end of the day. But they have such a large quota that they can't actually take their break. And that's a winning case, actually.
The law says you have to provide. You don't have to lease this, you have to provide. But we get so difficult for them, they cannot really eat on premises, take a lunch, guess what you just did? You violated the law. And that's what becomes problematic, because a lot of times I tell my clients, my workers, give them an hour. It's just much easier. 45 minutes. Do not make it exactly 30 minutes. It's gonna be a problem, because the reality is, what if the other person comes late? What if they come in late? It's very problematic. So normally, our Steven is ideal. No, it's not. It's 9 to 5 because it needs to cover customers on an hour.
I have a question, quick.
Sure.
Combine 30 minute break with 10 minute break?
No.
Okay, I thought so.
People like saying, in the past, you should be, not in the past. Look, operationally, I thought it made sense, but the problem is that you don't know, because stopping track of how do you know that she actually got the rest? So Chase is gonna say, well, prove it. How do you know that you didn't get much of the rest break? Well, it was an hour. No, that was lunch break. How do I know it was a rest break? It doesn't work.
And what's the best way to document the meal break?
Clock in, clock out.
Yeah.
Clock in, clock out through a punch in system?
Yeah.
Okay, perfect.
So someone like Anita will tell you what company she uses for,
Great.
clocking in and out.
I can tell you, I'm sorry.
No.
That's very important. We had a case, I used to work for a PO, and we had Mary Maids. They were our clients. They had about 25. And because they were out there on the job doing cleaning houses and what have you, they were just having the employees go out there, come back and clock in and out, but no clocks in and out for lunch. So it took one person to file a claim, and then they did, I don't know, I think it was like 5 or 10 people that actually, and they did a class action, I believe.
It's probably a class action.
Yeah, so what they did, they had to pay those employees for all those breaks, because there was no documentation. And if it is in HR and even in the labor law, I mean, if it's not documented, it doesn't exist. That's why it's so important that you guys have all this documentation for the employees to protect yourself, so you don't get in trouble with any.
Again, it is unfortunately, or for whatever reason, it is the employer's obligation to maintain records. You can say, well, they knew, they should have known. Well, they know how many hours. Well, how do you know? It is your responsibility, and that's where a lot of my clients get themselves in trouble. Unfortunately, it's because they're a great relationship. Nobody ever checked anything and looked at the clock in and outs, and guess what? If there's a problem, it ends up blowing up.
And I'm sorry, did you meant to say they clock in physically and clock out physically for the lunch break? or can it be like at the end of their shift, they're about to clock out and it asks them,
No.
did you take a lunch break? Yes.
At the time of when they
Well,
take their lunch,
hourly, yeah.
You're
because,
saying no?
Yeah,
No.
sorry, go ahead.
oh, no, if they need to clock in, if I leave at 1:59, I need to clock in when I go in and when I come back. They
Yes.
have, yeah, they have to clock in at that time.
At that
I'm
time.
sorry, was that your question? Oh.
No, like, I'm about to take my lunch break. Do I have to go and clock out first?
Yes.
Yeah,
Yes.
yeah, so,
Yes,
okay,
yes.
so,
Yes,
in-
yes.
Yes.
if we're in litigation and I brought a claim against an employer for a violation of meal and rest breaks, we get to look at all the timesheets, right? And if the timesheets say, hey, I clocked in at 12 o'clock, or I clocked out at 12 o'clock and I clocked back in at 12:30 for 4 years, that doesn't make sense, right? It's not actually what happened. So if you're retroactively clocking out and clocking in, that
Yeah,
just doesn't
the
look
exact
good. It
numbers
doesn't look like
don't
the
work.
records are accurate,
Okay,
right? And so,
So
Somebody
someone like
edit
me that's
those.
out in the field staging homes all over Southern California, take that tracker with us?
No, well, I know
They
that
can
there's.
write it.
Right.
The
The other
law
thing you can
doesn't
do-
require for you to use a certain system. If they have an Excel timesheet that you use for them, as long as they write it at that time, and then they write it when they come back. And like he said, it becomes iffy when you see everybody leaving at 12, coming back at 12:30. Then somebody either added that time card, or
Somebody's
somebody
messing with
went
it.
out there and
Okay.
just did it.
There-
Or you have a schedule.
There is an exemption, obviously, now, if they only work 6 hours and they wanna waive their lunch, cause they'll be like, I don't get hungry, I don't wanna only work for 6 hours. I know we did that, but the thing is, that waiver has to be for every single time. You cannot just get, I've had employers
Yeah.
that say, well, I had them sign a waiver every month. No, it's for every shift that they've skipped a lunch break, you need a waiver.
Yeah.
Now with the payroll companies, with them being app-based with the phones, timesheets are great, but the reality is paper logs, I have a problem with that because I'm terrible at that and it's gonna get lost,
Yeah.
so I'm sure with the payroll
I
company.
have a hourly app.
You should talk, well, you have
Yeah.
Carlos, I was gonna say you have
Yeah.
Carlos already.
Yeah.
You're with Carlos.
Yeah.
Yes, I am with Carlos, but it's like we clock in at 7:30 a.m. and then the shift ends at 4 p.m. and then right before when they're clocking out, it says, did you take a lunch break? And then they say yes, and they say what time to what time, but everybody just leaves it on the default of 12 to 12:30, and then they clock out.
No, you can get in trouble for that if that's somebody comes.
Well, good thing
because-
I'm here today. Jeez. Starting
So,
tomorrow.
what are you gonna do?
Clock out.
you need actual time.
And if you need a handbook,
I mean, I have to
What
have
about
We'll
break,
talk-
Okay.
what about breaks? Is there any need to force them to take those or document those? How
So
does that
you
work?
are not required under a case law to police them.
Okay.
But you have to just make sure you can provide them.
Okay.
However, inevitably, every case that I've seen for wage and hour, they'll say, I never took a lunch and never got a rest break.
Okay.
That's what they always claim. And
Because you have
again,
6, 7 employees, you can't check on everyone who takes
it's
a
a
break,
pay,
right?
now, recent cases that I've settled recently, the courts also kinda don't believe you when you say, well, I never got a rest break.
Okay.
You generally have a stronger argument on meal breaks because that's unpaid and you are clocking out. So like I said, you have to provide, but the case law for rest periods is you do not have to police them. You do not have to sit there and make sure, hey, did you get your rest break? Are you rested? Are you not tired?
So if they
You
don't
have-
take one, that's fine.
That
as
is
long as
their
you have it
choice.
in the policy
Yeah.
that states that they are allowed to take a 10-minute break after 2.5 or whatever
Yeah.
hours it is, then yeah, you have the documentation. in
Yeah,
it.
like they sign it
Yeah,
upon
but
onboarding.
yes, but if you don't have time clock, if you don't make them clock in and out for lunch, and then you get a claim, then
No,
what
there's
they-
a time.
Oh, no, I
Just
think what
the
she's
break.
saying
No,
is,
no.
so let's assume I had an employer client that was not that great about meal breaks. Then the court's gonna assume if you weren't that great about
Exactly.
overtime, you weren't great about a rest meal break,
Yeah,
I'm gonna also
the
assume you weren't
trend
that great
is
about
Yeah.
rest breaks.
Yeah, that's what I was gonna
It's-
say.
I'm sorry, so
Then
what
what
if I
if
just pay for the
No, I
lunch
think what
break?
she's
Is
saying
this
is,
still an
so
issue?
let's assume.
An hour, you have to pay for an hour.
Never mind.
Any
Well,
inconvenience is expensive.
And on top of that, just like he said, it has to be without any interruptions.
Yeah.
So if you send somebody to maybe work on something and they were already in the break and you pull them out within 10 minutes or so, then they have to start all over again.
So that's the problem, let's just talk it through.
And on top of that, just like you said, interruptions. So if you send somebody to and they were already
Is it 10 minutes?
and they were already in the break,
Yes.
then they have to start all over. A lot of companies do give 15 only because 10 minutes you cannot even get a cup of coffee.
Unless you have a break room.
And on top of that,
for them to take their rest breaks at that time also? No.
No.
We can.
Not to you mean to combine them, right?
The only thing
Yeah.
I would probably want to look at the industrial wage order and see what is covered for construction, because I have a feeling that, I know Anita's saying no, but I think ultimately if there's an agreement between employer and employee and we have a policy that says, by the way, because we're in a remote location and there are ways you could probably document that and probably do it, but I'd wanna look at the industrial wage order to see what the
Yeah.
wage order says, because that's gonna be dictated by that.
Yeah,
So. And construction is a little weird, so.
Yeah, that's why.
We're gonna cover wage theft now, and, wage theft is basically what someone's gonna say, you stole money from me, employer, you didn't pay me. And generally it's because you didn't pay me overtime, you didn't pay me for my meal breaks, you didn't pay me minimum wage. You are required also to inform an employee when you hire them, the wage theft prevention notice, which essentially you need to spell out in that notice, or the hourly rates, you're gonna get this, your minimum wage, this is your overtime rate, you have to spell all that out in the notice, so.
So that's one of the other documents that is required by law that you provide to the employees, and you have to give them a copy on that one. So what it is the form is asking for your workers' comp insurance, the employer, just in case they get injured. They have to have that information. It has to have, like he said, the hourly exempt, or, the salary, whatever it is, the overtime, when they're gonna start working, when do they get paid, and what office they get paid from.
Right.
So all that information has to be provided to them when they get hired.
So wage theft is also, it could be a mistake. I thought the hourly rate was $15.50 because it's last year's minimum wage, but it's actually 16. It doesn't mean that you're being malicious, but the reality is that's considered theft. Now, under California law now, the new, I hate to say this, it can be seen as a misdemeanor. So it's also can be seen as a criminal offense. So if you're purposely paying your employees in cash, underpaying them and not paying them what they're entitled to, you could be looking at criminal liability, which means you could be personally liable as a business owner. Wage theft is pretty serious for certain industries. That's why it's a big deal. It's not for every industry, but there are industries that are being affected by it. Anita, you want to cover time tracking requirements? You already kind of said it.
We kind of
just-
already, that one we kind of already did.
Thanks for these guys, great questions, we skipped through some of it, so, these are the time records we actually covered this, okay, so actually, Chase and I can discuss this over here, Chase. Generally, you have to go 3 years back for employee records, you have to at least keep 4 years of family medical leave of absence, because, if it's a disability discrimination action, again, it is your responsibility as an employer to have records, you can't say, well, we trash our stuff every year, it doesn't work that way. Just like the tax returns, you can't just. not
Sorry,
go
you
to
said
records.
4 years?
4 years
4 years.
retention?
Employee contracts, 3 years. The mandatory harassment training is every 2 years, so that's just the timeline. Personnel file, you have to keep it 4 years at a minimum. Payroll records are 4 years. That's how far back you can go for the lawsuit. So, when somebody files a wage and hour case or payroll records, they can go back up to 4 years. That's the statute of limitations. Health records are 5 years. Those are the ones that caught my eye. Termination process, I'm gonna have Anita probably talk about this and probably Chase a little bit about this, because this is when a lot of the.
You want me to go first? or you-
Yeah, sure. We're in termination process.
So-
Sorry, one question.
Oh.
Time tracking, can you do, however the company sets it, like, minute by minute or 15-minute intervals, or there are a couple options there?
It depends if they're an hourly employee, remember they work by the minute and over by, no, they work by the hour and over by the minute. So that means that, you can only give them a grace of 5 minutes when they come in, and when they leave, they can clock in no more than 5 minutes before. It used to be the seven minute rule. I don't recommend the 7 minutes because it's just cutting it, so I will say 5 minutes.
Okay.
Give them, like if they come in late or they come before, you don't pay them, but you also have to give them the same amount when they go home. Like if they go home at 3:30, if they clock out at 3:26, then you don't dock them those minutes.
Oh, I see.
So it has to whatever is more beneficial to the employee.
I see.
Yeah, and then.
That's why time cards become important, because you just punch in and out. That's why it
Yeah.
becomes so mechanical. Otherwise, you get the whole grace thing. It ends up being a problem, to be honest.
You were gonna say
Yeah,
Go ahead.
something.
I was just gonna say, yeah, there's a lot of litigation for employees where they work maybe 5 to 10 minutes after hours, after the time it closes, right? And so the last thing that the employee should be doing is, for you, is clocking out, right?
Yeah.
Because that can turn into, big wage and hour cases.
The overtime, the penalties, everything else.
Yeah, exactly.
My client had a driver, was essentially, everyone would leave, and then after they finished the delivery, they'd come back to clock out. Guess what? They were incurring overtime because now they were being required to come back to the warehouse to clock out.
Right.
And
The
they-
Starbucks had a big old, claim
Yeah.
on that.
Yes.
He has a question.
Yeah. Go ahead.
So this brings me to the point of the silent quitting, where nowadays we've got texting, emails, and things of that nature. After you leave the job, employers are still expecting you to answer my emails, answer my text, call answer the phone. I call. Have you heard any? You never heard anything?
Are you talking about being required to being called on your devices? That's part
Yeah,
of the-
after hours. You left the job.
Ends up being part of the
It's called-
reimbursement claims. So if I'm being a remote, or you're sending me an email after hours and you ask me to read it, and you're telling me to call me on my cell phone and ask me to, or be on Zoom after hours, that's all compensable.
Yes.
So be aware.
If they're hourly employees, forget it, don't do it.
Yeah. If they're off the clock, they should be off the clock.
Exactly.
You don't be contacting them. The problem with email, a lot of us will allow email access to let them check their emails on their phone, and you're not telling them to check email, but what if I
Yeah.
am like someone that likes to be anxious and I'm checking email all the time? That ends up being compensable, so
Yeah.
be careful.
What I recommend, because that we had that incident in one of the clients, to the person that's doing this, that always checking emails after hours, you need to send an email to them saying, please do not respond to any emails that you receive after 5. Shut down your
Yeah, I don't
computer.
like it personally. I won't ask anybody to do that.
Yeah, okay, but if
But
somebody's
no,
doing it, then-
I'm
You can write,
sensitive to that.
honestly, you may have to write up something. Hey, I noticed that you're sending me emails at 9:52 p.m. Why
Yeah.
are you responding to the email?
Yeah.
You know, A, I shouldn't have emailed you, or unless I did email you at 4 o'clock, but you emailed me at 9:30 at night.
and then if that
Maybe a
employee
month.
goes and hires Chase, then you say, I've been telling him not to, I can prevent him, I mean, he's doing it.
I wrote him up because
I wrote him
he
up,
or she
yeah.
kept doing it. And I got tired of it, and I finally said, look, cut it out. I don't want to pay. Somebody else mentioned, so you can also stop overtime. So you have employees that will tend to clock in a little bit early.
Exactly.
You can write them up, but you can't garnish their wages. You have to pay them for
You
all
have to
hours
pay
of
'em.
work, whether or not you approved it or not, which is a crappy thing as an employer, because if you have someone that's taking advantage,
Right.
that could be a problem.
Yeah.
So.
You can have a policy stating that all overtime needs to be authorized by whoever the manager is, and if that employee continues to do that, then you can write them up for that. Just like he said, you still have to pay him.
It has to be authorized, but the problem ends up being a lot of my employer clients were getting confused, saying, "Well, I didn't authorize it. I'm not going to pay it." It doesn't work that way.
Yeah, you still have to pay him.
Common sense says it shouldn't work that way, but that's not California law.
Yeah.
It just gives you the right to write them up then.
Yeah, that's exactly what it does.
The other big law that I wanted to cover. Did I just go-
Well, we didn't go over the termination process.
Oh, I'm sorry. We skipped it. Go ahead.
Yeah, so on the termination process, just when you wanna terminate somebody, make sure that if you're gonna fire that employee, if you're gonna fire them, lay them off, or it was your decision to let them go, make sure that you have everything in the last pay period, final paycheck. Everything that you owe them, including vacation time, or PTO, sick days that you don't need to pay that. And then, you need to provide the employee with the EDD notice. This notice is just basically letting the employee knows what the benefits are and how they can apply for unemployment benefits. And at that point, you tell them that it's not really up to you, that it's up to the EDD to determine whether they're gonna grant the benefits or not, but you providing them with the information. And then if they had insurance, then you need to provide them with the COBRA information on how it's gonna be covered, how it's gonna be processed. And then the separation letter, you wanna make sure that you have, if you're gonna do it via email or however, that you have it in writing, effective so-and-so date, you're gonna be terminated for the reasons, and explain the whole situation. If you have a severance agreement, make sure that that's also spelled out, and he can help you with that. And then the exit interview that's really optional, only because if it's somebody that's resigning, you wanna know what you did wrong as an employer, so you can kinda, make some, maybe fix things here, there with the managers and what have you. But those are all forms that are.
Well, I want to talk about one thing that you're right about. So when you were terminated, one of the reasons I don't like terminating people is they get fired, because you must pay them everything in that moment when you decide to fire someone. It's including overtime, accrued vacation, commissions. You can't say, I'm gonna run the check to payroll, because every day you do that is a vetting time penalty you have to pay. So normally I recommend, hey, come in on Monday, we'll have a conversation with you, and we need to talk to you, and by that time it gives you enough time to collect. Now, if somebody quits you have 72 hours to pay them. So that's something a lot of people get confused. It's not like 3 days, it's 72 hours. It's
Yeah.
very, very precise. There's a reason the law states that.
Weekends.
So,
Wait a minute.
yeah, because weekends count.
You said it wasn't 3 days. You said
If they
72.
quit, you have 72 hours. But if you decide to fire me,
72
Frank, you want to
clock
fire
hours
me.
or
Sanjay, I'm
work?
tired of you, I'm going to fire you. You better have everything that I'm owed
Yeah.
that day.
Is it like work days,
Is the
8
same.
hours?
No, 72 hours including
Clock
weekends.
times.
Calendar days.
So I quit on Friday, I give you notice on Friday, the check should be there on Monday.
Right, okay.
How much this applies for somebody who quits? How much of this, if any? Does this all still apply if somebody quits?
Always asking for the notices.
Oh, yes, all this includes, even if they quit. Now, the only difference is that if they resigned, then, you have the time to cut their checks. Like, if they give you notice, like if I give you my 2-week notice and I said Friday's gonna be my last day, then you should have that check ready for me by that Friday with everything, the basic.
Oh,
They-
what if they're just like, I quit, and then like,
They-
all these notices?
72 hours.
All the notices.
And then they
You
will
will
apply
mail
for
it.
EDD and they find out because the reality is EDD unemployment does not cover, if you resign, you are not entitled to unemployment. A lot of employees do not know that. So they're shocked, like, you mean? Yeah, it's because unemployment is for people that are being laid off. It is not for people that decide to quit. So
Even if
people-
they worked with you less than a year?
It doesn't really matter.
It doesn't matter.
I mean, if they quit, they're not entitled.
No,
Now,
I'm sorry,
like I
you
said,
get laid off.
EDD, no, like, the reality is EDD still, it drives me, and someone can attest this and critique it as well. EDD is kind of strange, they'll still give it to people even if they're resigned, but it's very clear, it's pretty much almost like black letter law. If they resign, they're not entitled to unemployment.
Okay, but if they get laid off,
They are.
even if they worked with you less than a year?
Yeah, I don't think it
Yes.
really matters, yeah, that doesn't matter.
And does
doesn't
that
matter.
affect a small business in any way?
No, because
Unless-
so that's what I tell my, so some of my clients wanna fight them on unemployment, I'm like, why? You've already paid into it, they paid into it, it's not your money, it's not like they're gonna cut them another check, it's like the
Okay.
state's gonna pay them.
Okay,
So
and
it
it's
doesn't
something
really-
that you've
Right.
been paying
Yeah.
into anyway?
Yeah.
Yeah, well, the reason that you as an employer, because you are paying that unemployment taxes, when you open your business, then they give you a rate for unemployment. And depending on how many cases or unemployment case people have filed against that, because everything goes into the like a bucket, and then from there it's gonna. So you want to fight it if it's somebody that was maybe a bad employee, attendance, performance, bad attitude, whatever the reason was, but you fire them. You want to fight those cases because you don't want that to come against your
I see,
bucket.
that's why I was asking, does it affect your
Yes.
like
Like
rate?
a long-
There's a
or-
rate, I mean,
Yeah.
at some point we realized honestly, but it takes so much time,
Yeah, it
it
does.
is a
Takes
very
years.
cumbersome process unless you have
Okay.
an HR department and you have multiple, if you have multiple, it is,
Yeah.
personally after a while, we stopped fighting it because it just wasn't worth the time. Because
Okay.
we were able to appeal it, we had employees that would appeal it, you have to show up, it got ludicrous, so I'm
Just
like,
let
what are you
it-
doing?
yeah, just let
No,
it-
but
Yeah, it's
she's
not a
right,
lot. But it, I mean, that's.
I'm not saying don't fight any of them, I'm just saying,
No.
there's sometimes it's not worth it.
Yeah.
Quick question.
Yeah.
Someone said, they've given you notice, and, instead of the 2 weeks that they gave notice, I accept their resignation right there and then.
You can do that.
Do I still have 72 hours to pay them, or do I have to pay them right there and then?
You accept the resignation, so you have 72 hours. Because they're essentially, you don't have to give them 2 weeks, and you can accept it. So what happens is someone says, I'm gonna leave in 2 weeks.
Yeah.
I'm saying, you know, it's not ready for 2 weeks, I'm gonna accept your resignation now.
Yeah, I'm
So you
accepting
accept
it
your
today.
hours.
Oh, but at that time you have to give them their final check with everything you owe them.
But in 72 hours, because it's not a termination.
I'm
Oh,
not
no,
terminating.
No, no,
They're
but
quitting.
you basically firing that employee, and I'm sorry.
No, no,
but
no,
you
no,
basically-
I know what you're saying.
They're
You
quitting.
basic- yeah.
I'm accepting they're
Yeah.
quitting, but I'm
No, no,
accepting.
But they
they-
given
I missed the
you-
point. I missed the step because
They
the
given
reality
you
is
the
you better
resignation
have the
in
checks
2
ready at
weeks,
that
so
time.
I don't expect to get fired until 2 weeks. If you fire me right there and then you fire me. You're not
No,
accepting
but
my.
I'm accepting your resignation.
Yeah, but my resignation
So-
was not
so
until the fall.
let's talk it through, Ashley, you're right.
Oh.
So I missed a couple of steps here. One is that if somebody says, hey, I'm gonna give you 2 weeks, right? A lot of times people don't stay 2 weeks. Now, having said that, if you know someone's gonna leave, I would probably have a check ready for them in a few days and say, you know what, since you're leaving, you're gonna accept your resignation and have everything ready. Because she's right, you're gonna have the same problem with the documentation. Cheers, I think we cut you off, right?
No, you didn't. You
Okay,
didn't. No.
so yeah, I mean, but, because if you
I
jump the
think
gun,
it's too exciting.
yeah, if you jump the gun, you effectively, it turns into a termination, then you can have a problem, you don't have the checks ready.
And if you let them go to those 2 weeks before, because they gave you 2 weeks, they will be able to apply for unemployment right there and then. And because the unemployment has 7-day waiting period, they're not gonna be able to collect for 1 week, but the second week before they go into their other job or whatever they were doing, they'll be able to collect unemployment.
But what if in those 2 weeks period, they end up damaging some things, or taking information from clients or something like that?
Well, that's a
That's
different,
your
that's a different
decision.
claim against that.
Yeah.
They would have
Yeah.
done it anyway, if they were planning it.
Mhm.
You don't need 2 weeks
Yeah.
to do it, they would have already done
Hey,
it.
they might-
If they resign and they give you, they already did it probably.
Um,
So, yeah, I love that.
I'm gonna skip the fast food one because I don't think it's gonna be relevant to most of us. I am gonna go back to.
Darn California. No, I'm just
Yeah.
kidding. I feel like it favors employees.
Hey, the other
He
one-
does.
The big one is the workplace prevention plan that just came into place July 1st. I haven't really looked into it yet. Hopefully Anita can give us a little bit more information on this one.
On what?
The workplace prevention violence plan
Oh.
we're supposed to have now.
So on that, I don't know if you guys remember when sexual harassment became effective in 2005, everybody had to present that to the employees, right? And it's a requirement by law. So now they did something similar, where they want everybody to have that training, but that training needs to be specific to your job. It's not like I can just come and give you a generic training. I have to talk to you, I have to train you, I have to do all these things, and you have to provide that training to the employees. It has to be done by somebody in the company, it has to be done by somebody and have all this information that I'm working on it. It became effective in July 1st. I started working on it and then I got super busy, but that's something that I'll provide to my clients along with the sexual harassment training if they get my services, just because it's very time consuming. I heard trying it, or somebody is charging like $5,000 for that training.
So the training itself is basically what to do if there's a violent interaction between two colleagues, between a vendor and a customer, and essentially what happens at that time. So if you don't have a policy, you don't tell them who are they supposed to contact if they are attacked, if there's a physical fight, if a customer attacks them, if a vendor attacks them, you need to have a policy and a plan of action for all those different scenarios. That's why when Anita is saying it's got to be very specific to your industry, because it can't be a generic plan. You need to say, I'm going to report to Frank if there's a fight between me and Chase. He's the supervisor. This is who you should be reporting to. And then there's other trainings like how do you prevent that violence? What kind of training are you giving to your employees so they're not really physically fighting with each other?
Yeah.
So, things of that nature.
Yeah, sorry, I didn't really dig into
No,
it.
yeah,
But
that's what I remember from the
Yeah.
thing. Now, the other big one is in California. Now, I think it's almost national. Non-competes are no longer valid. Even if you decide to put them in there, it's considered void. You can tell employees all day long they can't compete anywhere else. Cannot do it. Now, the one thing you can do is you can make sure they do not take confidential information. So
Okay.
that's different from,
Okay.
so non-solicitation and disclosure of confidential information is different from non-competes. I think a lot of employers get confused with that because tell employees all day long they can't compete anywhere else.
What about trying to steal your customer?
Non-solicitation is that
Joanna's
you
got it.
you can have them sign a non-solicitation. So non-solicitation, generally, like I said, laws, California courts are, depends on, if they're a high level, they take it more seriously. If you're a retailer and, somebody, it depends on the industry, to be honest.
The law says that I cannot stop you from feeding your family or eating.
I get that.
So they don't really stand up in court, to be honest with
And
you.
they're kind of fun, but the reality is you should be, you can, the question is how protected is your information? How confidential is it? If everyone has access to it, is it really confidential?
Yeah, the law
Well, then you
says
look at
that
public
I don't
domain,
feel
yeah.
it.
A lot of times what happens is,
So
that claim
they don't-
comes up
they don't
in
really stand
litigation
up in court.
where an
And
employee
they're kind of fun.
might be
but the
terminated or
reality is
brings
you
a
should-
claim against
you
the
can-
employer.
the question is how
Um,
protected is your
It could be for wrongful termination, compensation dispute,
Yeah,
but
the law says
the
that.
employer might bring a claim against the employee. So now that they're fighting against each other, saying, you stole my clients, you stole confidential information, for things that happened, either during the employment or sometime after the employment.
Yeah.
And then, you forget about how true it is, now you have leverage against each other and things become more complicated in the litigation. So that's a big component in this is like what she said, if somebody damages the property or steals my stuff, those are trade secret violations and interference with your prospective economic advantage, all those different legal things. Yeah.
Chase, this is your slide actually. Like, why do you? So, what kind of cases do you take? I know you're gonna tell us why you take on some of these cases. What are your reasons?
Yeah. So the wage and hour cases, like we talked about, the meal and rest break violations are sometimes they're a little bit hard to prove, but the overtime cases seem to be easier to prove. And when we compare overtime, when we say wage and hour cases versus wrongful termination cases, wrongful termination is very fact specific, emotional, can be more intense. The wage and hour claims tend to be more of a math problem, right? Like, did you follow the timekeeping process and did you pay them over 8 hours or not? And you can get more fact specific on it. But wage and hour cases are, I think, easier to handle for plaintiff's attorneys. But I have a couple points on why I think plaintiff lawyers like these cases. And one thing, and we can talk about this in a couple slides, is attorney's fees. It's just, just the economics. Employees can recover attorney's fees if they win a case under certain actions, and that is why plaintiff employment lawyers like to bring those cases. And I guess I'll just address it now while it's up there. California law has 1194.2. Like I said, the employee, if they win a case for minimum wages or overtime or some of these other pay stub violations, they can recover the attorney's fees. But if they lose the case, then the employer can't recover their attorney's fees against the employee, unless it was, it's called a one-way fee shifting statute, unless the case was brought in bad faith. Okay, and if the case
It's gonna be hard to prove.
Yeah, it's hard to prove. It's possible, but it's hard to prove. And so that's why the plaintiff employment lawyers like to bring those cases. And then the second point, and it's all supports one another, is like Joanna said, is that the employment laws in California are really favorable when you get into litigation and you have the burdens of proof that the employee needs to bring, or these presumptions. Like, for example, we talked about record keeping. If an employer doesn't have any records, the California law says that the employee, it's not the employee's responsibility to prove, which hours that he worked on October 31st of last year. He just has to say, hey, look, here's these policies. This is based on my information and belief. You put those allegations into a complaint and you submit it to the court. And then the employer has to disprove those with their records.
If they don't have any, guess what's going to be the testimony of the plaintiff? It's gonna prove, which hours going to rely on the plaintiff's testimony.
Yeah.
They have nothing else to go on.
And then there's other burdens of proof, like there's a 90-day window that's, there's become more litigation in this recently and more favorable to employees that, let's say an employee complains about not receiving their wages on time, or complains about overtime, and then that employee gets terminated in 30 days. So then there's going to be a presumption that the employee that the employer retaliated against the employee, right? And so then you have to go in and fight that as the employer. So these are all reasons why the cases are not easy, but it's easier on the employee than the employer.
Well, there's two reasons. One is like some of these cases are contingency, like personal injury, so they get a percentage for their attorney's fees. But if they get their attorney's fees motion, very common is they'll recover $20,000 for their employee, but their attorney's fees motion will be $1,000. Guess what? They're gonna say, well, I worked 100 hours and my hourly rate is $500. So there's two reasons. One is like some of these regularly get them granted because employees can't afford to hire all these someone until these rates. So that's why these cases are very common.
I'm all for fairness, but I'm gonna get all the businesses in California and I over to Nevada, and the employees can just stay.
You give them all the money.
Because it doesn't seem fair, it's subjective. Business owners put the money out there to get the economy going, and there should be a balance, it should be objective completely. And I get the employee side of it on both sides of the coin. So there should be a give and take, you know, the employer should be fair, 100%. The employees
You have no money.
I'm giving you a living, it doesn't, you know, you're able to feed your family, put your kids through college on my dime.
Put it
And I'm
on the
not even
ballot,
s-
Frank. Put it on the ballot. I mean, like, that's
Oh, we're
all
all gonna
guys
move?
can
Is
do.
that
I think that's all we had really. I think.
Wait, I have a
anything
question
else?
though.
Okay, sorry.
What's the statute of limitations? So like, once you fire them, like how long can you wait until they file this paperwork and stuff?
They can go back 4 years.
Yeah.
So 4 years later, after they're fired, they could go back. Put it on the ballot.
Well, yeah, it depends on what kind of claims they're making. Because region hour, and we cover the time limits in the presentation. They can go back. You can go back to 3 years, I believe, for arrest space. You can go back 4 years for appeal. So it really depends on what cause of action.
And then the other one is this type of cause of action covered through an expired? They can go back.
Only 3. Well, yeah, it depends on what kind of claim. Oh no, yeah, no, she's right. EPLI only covers wrongful termination and discrimination. It does not cover. You can go back to 3 years. But it is good to have EPLI because they'll at least defend the case, even if you have a reason or a component to your. Because if there's a cause of action for wrongful termination or discrimination, they will still defend the case, even if it's a reason.
Not a wages.
Sorry.
Yeah, no, she's right.
I just got a quote for the
EPLI covers.
EPL.
Yeah,
Thank you for
yeah.
the connection. So I just want to know what's my worst case scenario.
But it is good to
So
have.
let's just say somebody hires Chase. Let's just say whatever. Somebody hires Chase, and Sandra's representing me. And the worst case scenario, I lose. What happens? And I have the EPLI.
Well, it depends on what cause of action.
Let's just say wrongful termination.
Okay, so
What's the worst case scenario? Like, are they going to come after my assets because they're in an estate plan?
yes.
And
Okay,
let's just say
so
whatever.
one thing that I was thinking about too is one of the reasons that it's more favorable to bring a case is that employees can
And I have the
name
EPL.
individuals, agents, officers, managers
What's the worst case scenario? Like, are they
who are
gonna come after my
responsible
assets because they're
in
in an estate
the
plan?
labor violation. So that's something that we do is that we'll file it as a suit and we'll name the employer, but then we'll also name the employer's owner if name that person was engaged in that, right? So you could be named personally, and if it your question has a lot of variables, but it could depend on, you know, if you're saying that you have a case that goes to trial and you get a judgment against you and that judgment is entered, then we go into a whole area of judgment enforcement, and people will try to levy on your assets. So they'll record a judgment and try to seize whatever real personal or real property you
Yeah,
have.
they'll try to attach everything, and also, this is probably a side issue, but we do have employers, unfortunately, that commingle funds. They use the corporate assets as a piggy bank for their personal assets, and if you are not maintaining your records, or you didn't file your statement of information properly, you expired, or you don't pay the FTB tax, or, you know, those are things they can pierce the corporate veil and go after you personally. Now, if it's a harassment claim, you could be, your supervisor is personally liable, and you could be personally liable as well. So it depends on the cause of action.
But I can tell you that if he receives a claim for a wrongful termination, and he has the list, that he's gonna ask that employee, did they pay you on time? Did you had all these violations, and he can put all that stuff in there, can't you?
Yeah.
So it's not.
It's very standard to put all the cause of action. I mean,
Yeah.
disability discrimination starts from there, for retaliation, failure to accommodate, didn't talk to me, and inevitably there'll be 9 other causes of action. Because again, I'm trying to get to the attorney's. Well, Chase is trying to get to the attorney's fees provision because he makes more money doing the attorney's fees.
Yeah. So usually, like a worst case scenario is an employer company has to file for bankruptcy to try to release those claims. So I was a bankruptcy lawyer for a couple of years, but it didn't stick. So I'm doing employment. But I've done some of these cases where we've represented employees through bankruptcy, and I've represented companies that have had employment claims. And it depends on whether or not the company can get through bankruptcy to reorganize, or if they have to liquidate. And those claims are generally treated as unsecured claims. And it, like when we talk about variables, all the other types of claims you might have. But if it's a litigation-driven bankruptcy, you might be able to discharge those claims with a smart bankruptcy lawyer.
The reality also is a lot of these cases do not go to trial.
Okay, I was gonna say, can I just settle? Like, you know what, let's just
Yeah.
call
Look,
it a day.
you have to understand, from the plaintiff's perspective, they have to carry everything.
Yeah.
It's a contingency, they're paying all the deposition, they're paying everything
Oh,
until
I
there's a settlement.
see.
So if there's no settlement, usually they try to get a quick one, it doesn't really happen. It could be a year, 2 years, 3 years before they see any money.
Okay.
So there's a lot of pressure on them at some point financially to settle.
Okay.
You know, so keep that in mind.
Okay, see, this is a great seminar. So, and you guys probably are out of everybody's pocket, out of reach, we can't afford you. I'm a mom and pop business, and everybody, you look outside that window, all of Artesia's mom and pop business. How do we get a team like this so we can protect our business and, protect our families and things like, how does that happen? How do you?
We're not that expensive, if you think about it. We're cheaper than a lawsuit.
$300,000.
We're cheaper than a lawsuit. How about that? So, we can talk about it, but the reality is this is why we're doing this. I mean,
Yeah, 'cause
one of
I
my
wanna-
goals was to. This is the second time I've
It
done
seems
this
like
year.
the state is pro-employees, not employees.
Yeah.
That
is.
that
It
is.
is.
I mean,
There
if
you
you
go.
think
Right.
about it,
Right.
this
So,
is-
another argument,
The way you said, so you like to
You
put
coming?
in Nevada, I will.
I'm gonna sell my business tomorrow.
So we don't wanna, I don't wanna put anybody out of business.
Right, no.
Right, and we just wanna do what's
Look,
fair for
look.
employees.
Like, what
That's the
should
thing,
we,
though,
they
like,
need advice.
or maybe like,
Well,
like
look,
as long as you
there are
do
people that
this,
make
you're
mistakes.
good.
I don't think you are
Right?
the demographic that we're going
It has to
after.
be
I don't
fair,
think
like
Chase
you
is going
said.
after.
It has
The
to be
people
fair.
that Chase goes after are the people that are willingly and willfully not paying people
Yeah.
the proper. They're not paying the overtime. They're not paying the minimum wage. They're paying under the table. They're doing whatever they can. Those are the people that are problematic because they take advantage of people that cannot. They don't have the power.
Okay.
Right, but most of us that are here, I think, are trying to do the right thing. That's the whole
I
point.
guess I'm just afraid, like, what if we bump into like a bad employee that wants to like stab your back? And you're like, remember, you didn't pay me that one time. I'm gonna go after you.
If
Yeah,
you have a
Trying to
good
piss 'em
HR,
off, I mean, what do you do?
if
Because
you
that
have a
can
good
happen,
HR
man.
person that can really give you the advice, that can keep you up with all these new laws, then you can stop no one from filing a claim.
Right.
There's no way that you can do that. However, you will have all the documentation to prove that you try to do everything within the law.
Okay.
And at that point, it will be a lot easier for
Okay.
Sanjay to defend you as the employer, and it
Sure.
will make it harder for him to help the employee.
Okay.
So it's
The
just like
counting on you not having the documentation, if you do, like you already hired
Okay.
Anita and you hired us to go through the steps, you should be okay. It's
Yeah.
just-
Okay.
It's harder when it's the ones that have not done it.
Sure.
And then Sophie, you had a question. And we can-
Chase says, as a attorney for the plaintiff side, is it more of like your strategy to include like retaliation, discrimination, so that the insurance can take it? I mean, do you hardly ever do like just strict wage and hours?
Yeah, well,
Because the insurance has
So-
deep pockets.
yeah, sometimes that comes up, but we don't wanna bring a case that's
Right.
in bad faith or doesn't
Yeah.
have any
That-
basis for it.
That could be the
Right?
problem, yeah.
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 You gotta be careful because I know some people get excited and they wanna put every cause of action. You can suffer bad faith can be very expensive for an employee and be very expensive for their attorney because they can get
Yeah.
sanctioned, so.
Yeah.
This would be Anita. You are Anita, right?
Yes.
Just
That's,
checking.
that's what they told me when I was a
Okay.
baby.
Are you, or is there someone like you at a chamber level that could assist businesses in moving through this complex system? Because it seems like if we don't have the right tissue to blow our nose, we're doing something wrong, and you would be a great benefit at that level to assist us at this level.
I mean, not at the chamber, because this is my own business, if I'm getting the question
But
right.
rent yourself out.
No,
I'll
that's
be
what
your-
I do.
I'll be your manager.
No, I mean, that's what I do. What I do, I have clients that I go out there and I'll provide this type of services, just based. So what I do an assessment, and then once you tell me this is what's going on in my company, then I would say, oh, I think you need this, and this, or maybe all you need is a handbook. So I do this for, and I'm focusing on maybe the small to medium sized company. I don't go after like 1,000 employees. I think my limit will be like 500 for now.
That's
But I
big.
mean, yeah, but I mean, if that's the case, then we will do
Do
it.
you
But-
do mom and pop? Because
Oh,
I'm
yeah.
out there, so I talk to a lot
Oh,
of
yeah.
businesses.
No, I think she was saying that she does small business.
Yeah,
Okay.
small
Under
business,
five.
small
The
to
maximum
medium
she would
size.
go is.
Maximum.
Max,
Okay.
the max, yes, that's what, thank you if I said the wrong thing.
No, you
Sometimes,
did.
Oh, we
sometimes
gotta
I get
record
too
it. It's on-
excited.
it's on record.
Sometimes I get too
I love that.
excited, yeah,
Oh,
but you have my
we're here.
business
Oh,
card.
Okay. What are the rules for hiring undocumented workers, like, does all of this apply? Obviously,
Talking
probably
about-
yes.
So California does not care about immigration status. The
Okay,
reality
great.
is, if you're an undocumented worker, they are still entitled to all, and then Chiz can speak to this as well. Yes, it doesn't matter. Immigration status does not.
And how
You do
often-
have to fill out the I-9 form.
I was just gonna say, how often do you have to run the I-9?
You don't have to, because you're not an agent. So when they give you the I-9 and you fill it out, then you hire, when they hire you, the employee, then you write out the information they provided you. If ICE walks in,
Got
they
it.
provided me, I'm not
That's
an
all.
agent.
You pay them through IT.
You're not updated every year.
No.
It's not,
No, you just do it upon
You just
hiring.
do it, yeah.
Not to argue, but there's a code, US code in California and Fed, I think it's United States Code 1349, where you can't hire illegal immigrants. And I can go home and get you that.
No,
You can't
Not
do
in
that.
California.
California law does not.
So the
allow
employer
this.
won't be punished for that?
They
I-
not,
I-
Because I had some.
I have the code if you want.
So what happens if you hire illegal people? I'm gonna be very honest with you guys. I used to work for a manufacturing company where a lot of the employees were illegal, right? When I first started, I went to my boss and I said, "Oh my God, look at all these papers." You know, there was a lot of letters from the Social Security stating the Social Security belongs to a baby that's only 4 years old. You know, somebody that was already passed or what have you, right? I got scared and I went to him and he goes, "Anita, if you go and check on the bottom door, the full door is full of them." So I called them, and the lady at the Social Security office said, "Anita, they pay all their taxes," like basically telling me there's nothing you can do about it. We cannot do anything about it. The employers pay the taxes, the employee pay their taxes, and they will go after you because now they want more money. So what they're gonna do, if they get a lot of, like one company that they receive wrong Social Security numbers, if they do whatever they do, and then they come after you, they're gonna walk in, they're gonna ask to see your I-9s. If you have all your I-9s in place, then they're gonna check, they're probably gonna give you a fine if you don't fill them out correctly. However, they're gonna say, you need to get rid of all these people that do not have legal documentation, and they will force you to terminate those employees right there and then. But it's not until they give you the list of all those people, because we're not checking to see who has a good Social Security or wrong Social Security number.
Oh, I get it,
So that's-
but I'm just saying, because I study those type of things.
Yeah.
If it's on the books, I know about it.
As long as the employee's giving you what looks like a real Social Security card, and they're filling it, you're
You're not
filling
an
out the
expert.
Because we
I-9
don't-
with them.
we're
You're
not
an
running
And
it.
an ID.
You're not an expert.
Yeah,
You're not
because
an
we're not running anything,
Exactly.
we're just
Yeah,
filling out the form.
and you're not an expert,
Right,
so yeah.
so that's fair, okay, we're not.
But please
Until-
help yourself,
until-
there's a ton of food.
Sanjay, you have a question?
Oh,
So if an employee, provided fraudulent papers, but, they're paying all their taxes and the employer's paying all their taxes.
well, how do you know they're fraudulent? You don't know that. How do you know they're?
Well, I'm saying.
You don't know,
in
right?
case,
Exactly.
my question is, do they have all the rights to sue for, wages?
Yes.
Yeah,
things
they
like
have the
that?
same
So
rights.
California,
Yeah.
when somebody files, one of the questions in a lawsuit, it'll never come up, it does not matter if they're undocumented. You know,
Yeah.
It just, California doesn't care. Well, the courts don't care. They don't care the status. They
Except
want,
being paid.
they don't want employers taking advantage of people for whatever reason.
You an employer, you follow the
Social
rules.
is like fraudulent or whatever we.
That won't come up in that agent hour case.
Yeah.
It'll only come up that I worked this many hours, I was not paid my overtime, I was not paid my minimum wage, and that's what I'm entitled to. They don't ask about it all. This is all something that would be the IRS and something else. That's a different story.
You have a liability insurance.
Well, thank you all.
Thank you.
Thanks, everyone.
Now we depressed everyone.
Oh, my card is right there. Anita Mansell, that one. Oh, and by the way, you know those little yellow post-its that are under the table?
Oh, I see.
I don't know who wants to pick one up. Can you pick them up for me, please?
Moving on, too much to worry about, all these things that.
What it,
It says you want the free ER consult.
you got a handbook for free.
Wow, are you serious?
Yes.
Wow. Thank you.
Oh, you want this? I'm gonna get some business cards. This is the whole thing.
Awesome.
From
Oh, the
our
whole
side.
thing?
The whole thing.
Yeah.
Oh, wow.
I was gonna ask you about it.
And there's another one somewhere.
Okay.
Maybe under the chair.
Where's the other?
Yeah. For me? Yeah. Oh, thank you. Can I meet your card? Yes. Right over there. Ooh. Yeah. Oh, that was so
Thank you for. It's an offer. I mean, I don't know the structure now.
Oh,
you're
no,
a
no,
separate
no.
service,
Yeah.
but you work with them.
Yes, we are actually,
I just had some stuff.
So you have your own.
When things go wrong, right?
Well, my name is Luis. I'm also Indian, like Sunday. So I have a business actually on Pioneer. It's a pharmacy on the other side. Oh, is that right? Yeah, nice to meet you as well. Yeah.
Thank you all, thank you.
Yeah, you're right.
How do I?
I might have one in my bag.
And Ron Mara, he's gonna sign everything.